जी sorry. Majlis-e-Shura may by law in the manner prescribed for legislation for a manner impact part 1 of the legislative list validate all proclamations, presidential orders, martial law regulations, martial law laws and laws made between 20th 5th of March 1169 and 19 day specific koi section aapko?
So law, the law reforms ordinance, the power of making law has been protected by Article 270 by the Constitution.
जी.
तो जब एक मर्तबा वो power Constitution ने कहा कि ठीक है.
Sir, ये retrospective protection है.
Further के लिए भी है.
Post-facto approval थी भाई.
Further भी उसको आज तक utilize नहीं पाए.
I take your point. I'll move on to the next point. ठीक है? Sir, there I think, and this is where I differ from Mr. Salahuddin Ahmed, I think there are two principles which have to be safeguarded in the context of the constitutional history of this provision, where slowly all executive role has been taken away. This is not happening here. The executive role is still there in 145. But here, and the structure of the provision itself, where the dominant focus in the Supreme Court making rules. There are 4 limitations on the Parliament making laws regarding practice and procedure. Any act of Parliament under Article 191 Constitution 1973 will be subject to 4 restrictions, limitations. Firstly, the law has to be limited to practice and procedure. Secondly, the law cannot colonize or abrogate the primary role of the Supreme Court to frame rules. So if your lordships come to the conclusion, I don't support the view that Parliament can simply abolish the Supreme Court rules. That will destroy the complete autonomy of the Supreme Court. But if you
can there be an implied repeal? Mr. Salahuddin took the position that it can be expressly repealed. Can there be an implied repeal?
There can be implied repeal, but does that amount to destroying the power of the Supreme Court framing rules? That has to be seen provision by provision.
There can be implied repeal. Why can't there be express repeal?
No, there can be express repeal in relation to specific provisions. The third.
So what you're saying is that if there is a rule is made and consequently Parliament can undo that rule by making a law, so then the law will prevail.
Not in every circumstance. I'll explain.
How does one understand this second point of yours?
By the third point.
It does not abrogate the role of the Supreme Court.
By the third point.
Which we are awaiting to hear.
Thirdly, no provision of such law can violate the constitutional provision of the independence of the judiciary. So your has to look at every provision and see whether the repeal which has taken place of a particular provision impacts the independence of the judiciary or not. That is the method, and that is the thing which has been laid down in a Supreme Court judgment, will I judge side. The fourthly, no law can restrict jurisdiction or powers of the court on a harmonious reading of entries 55 and 58. So there is, these are relations on Parliament.
What about separation of powers? What about the constitutional principle of separation of powers? I find that missing over here. Why should that not be also a limitation?
My lord, I take that within the notion of the independence of the judiciary at the heart.
That's a separate thing.
Council,
they're two separate things.
Separation of powers is not restricted to the judiciary.
Yes.
What if the judiciary starts encroaching upon the powers of the legislature and executive?
And
that is how...
5 डाल दें, क्या फर्क पड़ता है? कोई फर्क पड़ता है?
So, I mean, there's a system of checks and balances as well.
Yes.
So the Parliament is empowered to legislate, and all that they have legislated is something which ensures to justice.
That is what I will show when I come to provision by provision, that none of these provisions.
Can you elaborate a bit more on your second one? The court cannot colonize or abrogate the primary role of the Supreme Court to frame such.
My lord,
kindly elaborate a bit more.
Example of that is the Bas Kakar case. It's a classical example as to why the Supreme Court struck down that law. What in the Bas Kakar case, the Contempt of Court Act 2012 did, is that in terms of actual cases pending before a particular judge, in which that judge had taken cognizance of, for example, a contempt on the face, in that, legislature interfered and that said that that case will go before another judge.
That's not practice and procedure. That's not
No,
practice.
but
and
I'm saying
procedure.
that is that.
No, but Baz Kakar was decided in the context of Article 204.
No, no, I'm giving you an example.
Not, but that was a different context. Give me an example of 191 when you say.
I'll give you an example.
Colonize or abrogate.
I'll give you an example. Let's take section 2. If there was any rule.
आप जरा एग्जाम्पल नहीं मुझे जरा पहले इस प्रिंसिपल को जरा समझाइए
वही मैं प्रिंसिपल
आपकी लिमिटेशन
मैं एक एग्जांपल से प्रिंसिपल को let's say that section 2 envisaged some kind of role of the executive in the constitution of the bench. That I would say would be a violation of 191 and the principle of the independence of the judiciary.
I would regard section 2 I mean section 3 actually.
सेक्शन 2 सर कमेटी जो बनती है एक कमेटी मेंबर चीफ
3 में है ना
जी
3 में
2 में है ना 3 में तो वो है ना सर मेंटेनेबिलिटी वाला सर
sorry 2 में है I would regard that as colonizing the
I know your
I mean,
lordship comment about
you've used very interesting words
Colonization.
colonize तो colonize
बस ये लिटरेचर पढ़ के थोड़ी सी गलत
colonize हो गया ना इसको इसलिए मैं आपसे ये you're making an interesting point but I want you on the plane of principle kindly to this point further.
Sir, this cannot be preemptively elaborated. This can only be understood through example because one doesn't know. Your lordship has to examine this provision by provision. That is why what I would be suggesting that there is a debate between that we should open the door and not be afraid of it, and there is a suggestion about closing the door. I would say keep the door open, but there should be certain padlocks on it.
नहीं उसके अंदर
The other way is that you
उसके अंदर जो
keep the door open but has sit the watchdog is sitting.
Yes.
And watchdog ensures that nothing, fundamental rights are not violated. So all your 5 points could be summed up by saying that as long as that law doesn't violate the fundamental rights, which includes access to justice, independence of judiciary.
Siddiqui
आप
साहब
ये जो आपने बात की है सेकंड ये आपका जो
Siddiqui
second है, how
साहब
does that square with the implied repeal?
जी
आपका ये जो second point है ना
जी
secondly the court cannot colonize or abrogate. आपने अभी कहा कि implied repeal is possible.
Yes.
Kindly explain to me
Sir.
how as a principle
sorry.
principle की बात
Sorry.
करें ना. I mean don't go into the nitty gritty right now. वो तो आप आगे जाके करेंगे. मैं आपका principle समझ रहा हूँ. How does this square with the you say there can't be express repeal, but how does this square with implied repeal?
No, sir, there can be express and implied. What Mr. Salahuddin argued that the parliament can get rid of the entire Supreme Court rules. I'm not advocating that on a particular rule.
How do we identify the core that cannot be repealed?
Yes.
Mr. Faisal, the core would be that in case, Mr. Salahuddin might be correct, you see, they can strike down the entire set of rules provided they don't violate the independence of judiciary. Your argument is the same.
No.
Why stand on any provision? Suppose theoretically speaking, if you bring out a law which takes away all the rules that are there, but it doesn't affect the independence of judiciary, maybe enhances the independence of judiciary, what's wrong?
My lord, I think what is underlining 191, and this is something which should be safeguarded at all circumstances, is at the heart of 191 is not the law made by parliament, but the internal autonomy of the Supreme Court.
There has to be some
Siddiqui
principle.
साहब, my question, please.
जी, जी, जी.
ये आर्टिकल 191 की जो लैंग्वेज है that starts with subject to the law in the constitution. There are very few articles of the constitution which starts with the word.
There are only 3.
Only 3. Yes. So does it means that because the constitution was framed in 1973 and the rules were framed in 1980, do you think that there is still a room is left for the improvement in the procedure with the passage of time? Like 184(3), whenever it has been used, ये पूरे मुल्क की बुनियादें हिला दी उसने जब भी इस्तेमाल हुए. तो do you think there is a room left for improvement in Article 184(3) or the procedure of the Supreme Court?
My lord, I think whatever,
Intentionally that has been done.
whatever amendments, and I'll take your ladyship through each of the amendments, whatever amendments have been done, I think that shows that reform is required under Article 184.3.
So can I just understand? आप ये कह रहे हैं कि 191 enables Parliament to make law.
Yes.
The principle to apply will be the independence of the judiciary. So the independence of the judiciary and the ability to make rules should be protected and preserved. But Parliament can make law with reference to practice and procedure.
Yes.
If they do make that law with reference to practice and procedure, so that's not undermining that principle of independence of the judiciary, but then we then go into the provisions that
Yes.
they'll start making of practice and procedure, and so then see whether that meets. So then my question is that isn't the constitutional mandate the opposite? Isn't the constitutional mandate saying that the Supreme Court, to the extent of how it regulates practice and procedure, will do it itself, because that is in its own internal matter, and the only thing that's stopping the rule-making ability is anything expressly provided in the Constitution or by law. Like I said yesterday, limitation hai, court fee hai, is tarah ki cheezein hai, which are procedure related, which you can't override through your rules. So ek system bana hua hai, uske andar they govern themselves internally. And it's interesting that in these 3 days of hearings, nobody has actually said to the Supreme Court that this is your rule-making power. What is stopping you today from making these rules? And why don't you exercise this power and call a full court meeting and actually exercise this power and bring whatever change you think today is acceptable? We're ready to argue this point and go into the delicacies of subject 2 and whether this is an expansion of jurisdiction or not. और आपके मुताबिक तो Supreme Court appeal की right भी दे सकता है. So problem किधर है?
If appeal is read into as procedure.
The point is कि अगर हमने independence of the judiciary को guard करना है तो where is the limit? कहाँ guard करें? कहाँ guard करें?
Your ladyship is
What principle should I follow?
Your ladyship is absolutely right. There is nothing stopping the Supreme Court from reforming itself, but a much more fundamental principle is involved.
Faisal, is पे एक example, just to quote an example, in Germany and in South Africa, they have adopted the concept of the lawful judge, and I'm sure you must be aware of that. और उसके लिए उन्होंने elaborate criteria laid down किए हैं कि how the cases are fixed and before which judges they will be fixed. So there's no intervention by any master of the roster. It's all through, if the Parliament tomorrow, in the interest of the litigants, legislates and on these lines, would they be competent to do that, and would that in any way, which protects the interest of the litigants, affect adversely the independence of judiciary?
Look, that is my precise point, that the issue is that does 191 create this delicate balance between preserving the internal autonomy of the court, but at the same time give a check and balance role to the legislature. That's the central point. That is why, regardless of whether there are internal reforms or not, the parliamentary role cannot be eliminated. But the parliamentary role, of course, has to come within the ambit of 191.
What would be the status of the Supreme Court in making rules in presence of this Act? Whether the Supreme Court can enhance power, make it committee from 3 to 5?
My lord, the first thing is, and this goes back, connecting both your questions, goes back that in terms of these rules, of course, there are certain rules of the Supreme Court right now which are in conflict with these rules. Like Section 2 of this Act is in conflict with Order 11. The review, the right to counsel, new counsel, is also in conflict with that. The Order, I think, 27 or 37.
Take a stand, Mr. Siddiqui.
Yes.
Take a stand. Don't beat about the bush.
Yes.
Direct question has been asked to you.
Yes.
If tomorrow the full court says that this committee consists of 5 members, can they do it? Or will the law, this act be
They
the,
can't.
Section 2 be the constraining limiting power?
Or is there any restriction in the act?
Give a straight answer.
Sir, after this act, I don't think there can be enhancement in terms of section 2.
So that means the act trumps the Supreme
This is
Court.
not
As far, because it doesn't, unless and until your lordships someone can challenge section 2 on the
Mr.
ground
Siddiqui, the
that
problem-
having a 3-member committee violates fundamental rights
You see,
or the independence of the judiciary. If
Siddiqui,
you
that's-
can't challenge that, then enhancement.
See, are the rules binding on a bench? Whoever makes the rules of the Supreme Court, are they binding on a bench of the Supreme Court?
Yes, I think that's the law. The rules would be binding.
On the bench itself?
Yes. Unless that particular rule is suspended through a judicial
No,
order.
no, on a bench. A
Yes.
rule made through administrative power, is it binding on the Supreme Court exercising judicial
It's
power?
delegated legislation which is made under Article 191, I think. So I think the rule would be binding, and there are numerous judgments
No,
where.
judgment ko chhodi na, we are talking about now constitutional matters here.
Question is.
Let me finish my
Ji.
chain of thought. There is a rule, whatever the rule says, a 3-member bench says that this rule, in our opinion, contravenes some fundamental right.
Yes.
Therefore, we will not strictly follow it. So surely it's not binding, or you're saying that the
No.
bench cannot pass such an order?
No. I'm saying unless, if your lordship declared the rules as ultra vires or a particular rules, of course they are not binding, but unless that
Okay,
is.
now we take the discussion a bit forward. If a bench of this court states that the rules under 184(3) have not been formulated in the Supreme Court Rules 1980, and therefore matters, till such rules are made, such matters should not be fixed for hearing, excluding habeas corpus matters. Can such a bench pass such an order?
If there is a constitutional basis for it, I
I'm
mean.
just asking you a thing, yes.
My lord,
184th at existing rules,
My lord.
there are, just head, you know.
Ji, ji.
I'm not talking of hypotheticals, I'm talking about the rules 1980 as they are. A bench of this court says since 184(3) petitions have been filed and the mode and manner of how they should be heard has not been determined in the rules, can a bench pass such an order?
Yes, a bench can pass such an order if the bench can
And,
show.
and can the bench then say, let the full court make such rules?
On the first part of the question, the bench can pass such an order if such a restriction can be inferred or is present in Article 184(3), that 184(3) powers cannot be exercised until rules are made. If the bench holds that rules, unless rules are made.
I'm saying if, no, I'm saying it has done it. Now, either you say it's not permissible or it's permissible.
If a constitutional basis can be shown for
Yes.
that, I think, of course.
Okay.
I mean, if the rules are violative of
So
the
when
constitution.
there
of
is,
course.
there has been a case where a bench,
Yes, I know,
very
I'm aware of
bench of this court said that the rule should be enacted by the full court.
Yes.
Now, if even exercising judicial power can be thwarted by saying no, then how do you get the rules made? It all depends now on the person of the Chief Justice. Now, please explain that to me. I mean, why are we just skirting the issue, hypotheticals? Why are we not coming to actual practical things which are happening in Pakistan where cases have been decided and sort of all over the place, just take the bull by the horn and answer
Sir,
the
I'll
question.
come to that. I'll just cite two judgments.
नहीं, judgments किस आप I mean, I just want to know the clarity on this issue.
मैं वो खत्म कर दूं, 1 मिनट दीजिएगा
चलें।
मुझे, सिर्फ 1 मिनट. There are two judgments, if your lordship, and I will not read them because I've
You
already.
can just add to that. Parliament can't make it. A judicial order cannot ask for these being made. So at the end of the day, it is all power vests in one individual called the Chief Justice of Pakistan, and that is
That
final.
is exactly my next point, but I'll just, because I just want to hurry. There are three judgments which your lordship may look at. At page 5, the first judgment, 92 SCMR 1208. this is where I draw this principle, where Justice Ajmal Mia,
12,
Sir, Afzalullah, sorry,
no, 120.
1202, where they say that we will not follow such statutory provisions and it will not override the rules which violate the independence of the judiciary. So this is where I draw that principle. There are two judgments.
But this judgment says that the rules will prevail
If,
over the statute.
yes, if the statute violates the independence of the judiciary, that's the criteria. But as a general principle, there are two judgments. One is from India, AIR 1964 Supreme Court 855. It's all written there, in which this conflict came before the Indian Supreme Court.
Where is it written in your booklet?
Page 5, top of
सर ये पेज 5 पे फर्स्ट 2 पैराग्राफ देखिएगा, और अगर ऊपर ही देखिएगा तो मैंने एक जजमेंट दी है AIR 1964 सुप्रीम कोर्ट 855, in which a conflict between a rule of the Indian Supreme Court as well as an act came, and they said the act.
I still don't know, you're going again around. Simple proposition is, no, sorry, you have to answer these questions. So all power vests in the Chief Justice, not in the full court, because full court is then dependent on whether the Chief Justice wants to call a full court meeting or not. The last full court meeting before the one that was called on 18th of December was about 4 years before. Prior to that, a lot of issues had accumulated which have still not been addressed through the full court meeting. So why are you hesitant in calling a spade a spade?
Sir, I'll answer that question now. My lord, the proposition which has been put forward, and this is one of my objections on the Ghulam Muhyiddin case.
फिर आप कैसे पे चले गए?
जी, सर
आप जवाब तो दे
मैं
दीजिए।
दे रहा हूँ।
कभी आप इधर चले जाते हैं।
That is the first
नहीं,
case.
हम नहीं,
मैं जवाब दे रहा हूँ।
आपको मैंने एग्जांपल दे
मैं
दी है।
जवाब दे रहा हूँ, मैं जवाब दे रहा हूँ, प्रिंसिपल स्टेट कर दूँ।
अच्छा चले, मैं आपको बता देता हूँ, अब चलें, हम इस कानून को उड़ा देते हैं, ठीक है? इस कानून को हमने उड़ा दिया, ऐसी मफरूजा दे रहा हूँ, ये कानून उड़ गया, ठीक है? अभी कोई रूल बनाना, मैं नहीं फुल कोर्ट मीटिंग करता हूँ, आप करेंगे क्या मुझे जरा बता दीजिए। नहीं ये देखिए फैसल साहब, you are a highly acclaimed constitutional lawyer, so praising me or anyone else should not be a substitute for responding to a query. A constitutional query I'm asking you.
अभी यही क्वेरी आपका।
आप फिर आप इस केस में ले जाएंगे गुलाम मुहय्यिद्दीन में?
अब मैं कोई केस साइट नहीं करूंगा, आपके सवाल का जवाब दे। सर, the independence of the judiciary is not linked or is not threatened if the role of the Chief Justice is reduced. Now, that is not the principle. That I think
it took you a long time to say that.
Yes. No, I've written that here, sir.
You haven't said it.
That here. So this whole debate that the master of the roster must be the Chief Justice has been elevated to a constitutional principle. It is nowhere in any case law as a constitutional principle. As Mr. Salahuddin rightly pointed out, its whole basis is in terms of judicial history and in terms of statutory law. Ghulam Muhyiddin case is the first case which lays down that the Chief Justice, being the master of the roster, is linked with the independence of the judiciary. Your Lordship will find no case which makes this link. The link has always been with the independence of the judiciary linked with the Supreme Court itself, not with the particular...
Mr. Faisal Siddiqui, as far as the interpretation of judgments, whatever has been decided, you can give a lecture in a law school. Okay? Here the full court of Pakistan is sitting. We don't want to be given a lecture on precedents. We want to be enlightened by the understanding of the Constitution, which we keep saying is an organic thing, pulsating, evolving, catering to all sorts of situations. I mean, if you're just going to be stuck with the case law, then we should just take a lecture in some law school.
My answer is...
There is no constitutional input then coming.
My answer is that there is nothing in the Constitution...
The context of that, what you're citing from that judgment is legislative intervention. But the problem is not whether the Chief Justice is the master of the roster. That is not the context of what we are considering now. The context is, and let me therefore ask you the question which I have asked Mr. Salahuddin and Mr. Zaid Ibrahim.
I thought if we talk about which question comes first, now another question has been put on another question. Can you answer mine and we get on with it, and another question can be asked. So please don't mix up my question with other questions. You respond to my question. Let another question be asked after you've given an answer, or you can keep your answers safe till you finish your submissions.
My lord,
I don't want my question to be added on to when I have a clear-cut question. Hopefully you've understood it. If
Yes,
you
I've
haven't, I've explained it further.
yes,
Thank
I've
you.
understood. If I may answer
Ji.
that question. Sir,
I
thank
thought
you.
you had finished with your answer.
No, sir, thank you. Sir, my answer is that reduce.
Never take my permission.
सर
Double standard.
नहीं सर आप मुझसे
अरे कोई बात नहीं,
सवाल
लाइन
कम
तो नोट
पूछे।
आगे बढ़े।
बड़े सवाल कम पूछे इसलिए मैं रिलैक्स हूँ
Are you taking the permission for?
चलिए आइए
granted
आगे
or-
बढ़िए।
sir
जी।
sir there is nothing in the constitution which equates the chief justice with the Supreme Court, and what has this law done?
Why don't you say so? End
Sir,
of story.
I
What's
said-
more to be said
Sir,
then?
what is this law?
But
सबने
Mr. Siddiqui,
एक
आपका
मिनट
answer-
एक बस
आपका answer हो गया?
सॉरी
Is this your answer?
नहीं आंसर हुआ है, बात तो कर लीजिए, बात कर लीजिए। वैसे सिद्दीकी साहब, मैं आज मैंने सबसे कम सवाल पूछे।
सेक्शन 2 पे तो फिर आपका मैं ले लूंगा।
सिद्दीकी साहब, मैंने आज सबसे कम सवाल पूछे। कम से कम यही राइट मास्टर ऑफ द रोस्टर को दे दीजिए प्लीज।
इसका जो कॉन्टेक्स्ट है ना वो बात का वो ये है, जो मैंने सवाल उनसे किया था अपना सलाहुद्दीन साहब से, जाहिद इब्राहिम साहब से, दिस लॉ आप तो इसको बड़ा रिस्ट्रिक्टेड कर रहे हैं ना, बट व्हाट दिस लॉ डज इज इट मेक्स पार्लियामेंट द मास्टर ऑफ द रोस्टर फॉर द सुप्रीम कोर्ट ऑफ पाकिस्तान।
Sir, you
आप फैसल साहब नहीं कर रहे
nothing
अभी
in
तक।
this law will done.
इसको ये असर इस सवाल का आप जवाब दीजिए।
My lord, there is
इसका
nothing in
जवाब
this.
दीजिए पहले साहब के
There
सवाल
is
का, फिर
nothing
सवाल
in
का।
this law which makes Parliament the master. I mean, what has happened to the Chief Justice under Section 2? Has his role been eliminated? He is one of the members of the
No, you're
committee.
missing the point. You were present.
आप अपना जवाब तो सुन लेना आपका पहले। आप जवाब दीजिए प्लीज।
Sir, in terms, because there is no constitutional provision which gives this elated position to the Chief Justice, and the Chief Justice is equated with the Supreme Court. For example, giving the power of the constitution of benches to three senior most judges, how does that violate the independence of the
I'll tell you.
How does
आप
that
बात तो
violate?
कंप्लीट कर लें प्लीज।
Because it is, that committee is the creation not of the full court, but. or with
मैंने
the
आपसे दो
supervision
तीन
of the
बातें
full
और भी पूछी थी। अगर चीफ जस्टिस फुल कोर्ट ना कॉल करे, अगर चीफ जस्टिस कुछ ना करे, तो फिर पार्लियामेंट ने कर लिया एक काम, ठीक है, मुझे करना चाहिए था, नहीं किया मैंने, तो किसी दूसरे ने कर दिया, तो अब वो कॉम्पिटेंस है, तो अगर मेरे ही में कॉम्पिटेंस है, चले वो बात भी मान लेते हैं, नहीं है तो फिर इसका मतलब एक लॉक जैम हो गया, क्योंकि चीफ जस्टिस ने कहा मैंने तो करना नहीं है किसी सूरत में, और मैं किसी और को भी नहीं करने दूंगा। तो बुनियादी बात तो यहीं आके ठहरती है ना। अब सादी बातों को सादे अल्फाज में बयान कर देना, इतने जजमेंट्स, ये पहले इशू आया नहीं था सुप्रीम कोर्ट के पास, तो नया इशू है, तो आप ज़्यादा आइन को मद्देनजर रखते हुए उसकी तशरीह कीजिए ना। अगर हम आइन की तशरीह सिर्फ जजमेंट से करने बैठे तो फिर हमें टेक्स्ट बुक उठा लेंगे, पढ़ लेंगे, उसमें वकीलों की ज़रूरत नहीं है, उसके कॉन्स्टिट्यूशनल लॉयर्स की भी ज़रूरत नहीं होगी। आप यही का फलां आप पढ़ लीजिए बुक ऑन कॉन्स्टिट्यूशनल लॉ, आपको सारे जवाब मिल जाएंगे। नहीं, वहाँ जवाब नहीं मिलेंगे, क्योंकि अब जो चीज़ें हम देख रहे हैं वो पहले नहीं देखी गई थी, और हो सकता है पहले गलत देखी गई हों, ये भी मुमकिन है। तो अपना विजन खुला रखना चाहिए, बेशक वो मेरे खिलाफ बात हो या मेरे फेवर में हो। इधर तो मैं अपने फ़ायदे की बात नहीं कर रहा हूँ, जो आपको इसमें कोई रुकावट होना चाहिए कि आप चीफ जस्टिस के सामने खड़े हों और चीफ जस्टिस कह रहे हैं कि आप मेरे इख्तियारात में कमी ला रहे हो, तो आप हिचकिचाहट क्यों, आपकी तरफ से क्यों ये हिचकिचाहट है?
नहीं, मैंने तो क्लियरली स्टेट।
निकरा वज़ीर आज़म अनवारुल हक काकड़ एक रोज़ा दौरे पर कोयटा पहुंच गए। कोयटा इंटरनेशनल एयरपोर्ट पर बलूचिस्तान के गवर्नर मलिक अब्दुल वली खान काकड़, निकरा वज़ीर आला मीर अली मर्दान डोमकी और निकरा विफाकी वज़ीर दाखिला मीर सरफराज बुख्ती ने उनका इस्तकबाल किया।
I didn't ask. Sir, I'll move on to the next, but I'll come back to, and your lordship's question was
270 ये आर्टिकल 270 आप पढ़ो।
निगरान वज़ीर आज़म
Majlis Shura may by law in the manner prescribed for legislation for a manner impact part 1 of the legislative list validate all proclamations, presidential orders, martial law regulations, martial law laws and laws made between 20th 5th of March 1000.
Actually,
Yes, I can answer. I didn't ask. Sir, I'll move on to the next, but I'll come back to and your lordship's question was
270. ये आर्टिकल 270 आप पढ़ रहे
जी सॉरी Majlis Shura may by law in the manner prescribed for legislation for a manner impact part 1 of the legislative list validate all proclamations, presidential orders, martial law regulations, martial law laws and laws made between 20th 5th of March 1169 and 19 day specific कोई section आपको
So law, the law reforms ordinance, the power of making law has been protected by Article 270 by the Constitution.
जी जी
Will your only
I can't answer that.
Will your only remedy then be to file a writ petition against the Chief Justice to convene a meeting of the full court?
My lord, I think it's
Or there is no remedy?
No, I think it's a question which requires serious consideration. I can't answer that question without seriously thinking about it. But because the Supreme Court did not do anything about these issues, that is why Parliament intervened.
Don't use the word Supreme Court. Use a please. You don't condemn all of us or any of us. The Chief Justice. If it is to be condemned, then point me to the Chief Justice. Don't say the Supreme Court. You use, sometimes they use being interchangeably. I think they're very different. The Chief Justice, all 14 of my colleagues want to full court meeting. I don't want to call it. End of story. So are they all to be condemned equally with me?
Sir, we all have our sins, we all have our weaknesses.
देखिए ये बातें देखें अगर आपको ये हम फिर आईनी बातें नहीं कीजिए ना फिर असूली बातें ना करें नहीं फिर आप कहें कि जी हमें सबको खुश रखना है एक गाड़ी चलाना है हम सबको खुश रखते रखते बहुत सारे मसाइल खड़े हो जाते हैं साफ साफ बात करें इसमें मुश्किल बात क्या है
I have categorically stated the position.
इसमें एक बात ये बता दें कि क्या चीफ जस्टिस पाबंद है रूल के क्या चीफ जस्टिस ने रूल के ताबे हल्फ उठाया या कॉन्स्टिट्यूशन और लॉ के ताबे हल्फ उठाया
Sir,
तो चीफ जस्टिस की मर्जी हो क्योंकि हल्फ नहीं लिया रूल के इसलिए कहते मैं जो करते हो कर लो
I think the point is, your lordship knows the answer to that. I mean, there can't be a rule, there can't be a law which violates the
But coming
constitution.
back to the question of interference in the independence of the judiciary, Section 2 and 3, they clearly vest the legislature with the power to constitute benches, to fix their number, and it makes it obligatory.
Let's take Section 2.
Obligatory to do so.
So, let's say Section 2.
Fair enough.
Yes.
Now, if it makes obligatory to do so, it is actually dictating the committee how to act.
No,
Is
sir.
that not interference?
My lord,
Okay,
where
the
is the
committee
dictate?
says, okay, we don't follow.
There are
Section
3 members, the Chief Justice who used to do it on its own, now does it along with his 2 senior colleagues. How can that be a violation of the independence of the judiciary?
What is wrong is that an entity which has nothing to do with the internal working of the Supreme Court is interfering.
My lord,
And when
if
it
you
is
eliminate...
interfering- When it is interfering, it is directly affecting the working of the court, and it's a handle on the Supreme Court to pick and choose in what way it wants the matters to be heard.
My
I
lord,
think I will agree with Ijaz Sahab and I'll take it forward. And why don't you say, yes, it is interfering? Let's say it, let's accept it for the sake of argument. Yes, it is interfering. Why don't you say, because the Chief Justice, you are not doing your job? Why can't you say that?
So the very
Why, what's the hesitation in saying
No,
that?
there is no hesitation.
Because you are not fixing urgent cases. You are fixing cases at random, which may, I mean, I'm putting this allegation on myself. So let it not be understood that I'm putting it on somebody else. I'm fixing cases which I want to. I'll say Mr. Faisal Siddiqui's cases will not be fixed at all. Your practice goes for a 6. I'll say only cases of Shahbaz where he should be fixed or whatever, whichever council should be fixed. Okay? You can't do anything, right? But so why don't you say, even if it is interference, it is good interference? Now the only question, back to question of my lord, जो जज साहब ने पूछा था पहले ही दिन से पूछ रहे हैं, और वही मेरे ख्याल में असल सवाल है, कॉम्पिटेंसी की वाली बात रह जाती है. अदरवाइज वाई यू हेसिटेटिंग से आप लोग अपना काम सही करें तो यह ना लेजिस्लेशन की जरूरत बनती ना कुछ. अब जब लेजिस्लेशन बन गया हम कहेंगे हम किसी से अकाउंटेबल नहीं है. हमारे पास जितने केसेस बढ़ते जाएं हम फैसला करें, ना केस एक केस सुने दिन में 50 केस सुने, हमारी मर्जी है. ठीक है? नहीं, सॉरी, इस तरीके से नई चीज़ें चल सकती हैं. हर अदारा को खुद एहतसाबी करना होगी सबसे पहले, इससे पहले कोई और उसकी एहतसाबी करे. तो पता नहीं, ये सीधी सीधी बात है. अब सीधी सादी बातें करें. अब केसेस में हमें उलझा करके घंटों चल रही है बहस. मतलब
frankly, when I look at Section 2, I see no violation of the independence of the judiciary. Yes, if that principle that under no circumstances Parliament can ever say anything about constitution or benches, then of course, then Section 2 goes. But I don't think if anyone point out any element which violates the independence of the judiciary in terms of the committee. And it is a misnomer that the Chief Justice is no longer a part of the constitution of the bench. He's one of the members. His role has not been eliminated. I move on to the second one, which is the most difficult one, which is, and Justice Shahid had asked a very important question about framing rules, framing rules. And I've dealt with that in my note. Your Lordship may have a look at that. But I'll move on to the second. But that's a very important question. There is no provision which says that rules should be framed. It says determining procedure, and I've tried to answer that in my note. Thank you, sir. Sir, 3. Now, it's a very important, this is the only provision which I would ask your Lordships to read down. This is the only provision.
Which is
Section 3, sir.
3.
What Section 3 does is that it says that there is this committee will at an initial stage look at whether these petitions are maintainable, whether the two conditions in Article 184(3) are present or not. Does it satisfy it or not? Now, this is clearly, as His Lordship Justice Mansoor has held, this is clearly a judicial adjudication. And this committee is really acting on the administrative side. It's obvious from the language of this provision. Now, there is nothing unusual, of course, about this initial, examination of these. The US Supreme Court does this. There is no hearing, there is no reasons at the leave granting stage. So the real problem is not that. The real problem is...
There is a problem here. With all due respect, your analogy is wrong. And I'll tell you why your analogy is wrong. The Supreme Court of the United States applies what is called the rule of 4.
Yes.
That out of the 9 judges,
yes,
at least 4 must agree to hear the case. That case goes to full hearing. But this scrutiny that you're talking about, that is not done by a committee of 3.
That is why I was going to add.
That is committee, because they all sit en banc.
No, sir, that is what I was saying. What is not unusual is no reasons and hearing is given.
No, that is not the problem with Section 3.
Sir, मैं वही तो बता रहा हूँ. Your Lordship is saying that when those 4 judges sit,
No, it's not the 4 judges. They have what are called conferences. I think every second Saturday they have a conference in which all 9 judges sit, and the cases are put up in conference. Any case that musters 4 votes out of the total 9.
Yes.
It's not a committee of 4 that sits. All 9 sit. The full court sits. What we would call the full court. That sits, and if 4 out of those...
and 5 when there is a grant of a stay order.
Sorry?
5 when there is a stay. Yes.
आप तो सेक्शन 3 की बात कर रहे हैं ना?
जी.
तो अगर 4 जो हैं वो नहीं, 4 वोट उसको नहीं पढ़ते, cert, what they call cert denied. ठीक है? So it's not that there's a separate committee. Whatever they do, because they have their own, because they always sit en banc. यहाँ पे मसला क्या आ रहा है कि थ्री जो what my learned colleague Justice Mansoor Ali Shah has stated in a very clear statement of principle that the power of adjudication cannot be in the hands of any administrative committee. The context in which my learned colleague gave judgment was registrar, but as a matter of principle, with all due respect, it doesn't matter whether it's a committee, no matter how eminent or senior those judges are, the problem remains the same. So the US example, I'm sorry, is not...
I was giving it for a different reason, if your lordship
आप ये भी
allow
बता
me-
दीजिए कि अगर हम देखें एक मुल्क से दूसरे मुल्क के एग्जांपल्स हम देते रहते हैं, हम ये भूल जाते हैं कि अमेरिकन सुप्रीम कोर्ट में 120 केस से सालाना फैसला होता है। अगर आप सुप्रीम कोर्ट, अगर आप इंग्लैंड की बात करें तो फिर नंबर्स हमें दें। हमारा सिस्टम बिल्कुल फ़र्क है। हमारे सिस्टम में हर कोई सुप्रीम कोर्ट जब तक नहीं आता खुश नहीं होता है, या CPLA में आएगा या CLA में आएगा। वहाँ ये सिस्टम है नहीं, बहुत कम केसेस होते हैं। तो अगर आप हर केस पे बैठ करके फुल कोर्ट ये तयन कर सकता है, ये वाले सुन लें ना सुन लें, तो आप ये सारी बातें फिर बताइए ना। अगर आपको एक एग्जाम्पल दूसरी जगह से लगाना है तो फिर अंग्रेजी में कहते हैं कंपेयर एप्पल्स विद एप्पल्स एंड पेयर्स विद पेयर्स। ये तो नहीं हो सकता कि आप एग्जाम्पल ले लें और उधर तो जी 120 केसेस हैं। अच्छा 120 केसेस में अगर पूरा अमेरिकन सुप्रीम कोर्ट बैठ के तयन भी कर ले तो कितना वक्त लगेगा? आप बैठ करके 56,000 केसेस को तयन कर लें, वो बात ही नहीं होगी, वो अलग बात है।
तो ज्यादा होते हैं जी।
Let me clarify.
आप
Cases run in several thousands.
जी जी, several thousand.
Out of those, only
जी,
100 or
हमें
odd
देखिए जो चीज़ हमारे
pass the
पास
rule
है
of
नहीं,
law.
मुझे नहीं पता। अगर आप कोई चीज़ फाइल कर रहे हैं हम पढ़ लेंगे
Sir,
उसको।
the only reason I cited that, I agree with you.
US Supreme Court की Wikipedia पे
I
page है।
agree. I actually agree with you. What I'm citing it, the problem with the provision is not that reasons are not given or there is no hearing. The problem is this maintainability adjudication cannot take place on the administrative side by even a committee
आप
of
रिपीट
three.
कर रहे हैं बार
जी।
बार 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 बार।
नहीं, देखिए इसका हल क्या है? इसका हल क्या है?
रीड डाउन करें।
इसको रीड डाउन कर दें और रीड डाउन इस तरह करें कि the scrutiny may take place, but whatever the petitions are should be put up with the scrutiny to a judicial bench. This is the way to say ये सिर्फ ये आपको करना है और not maintainable.
वकील साहब, आपने सेक्शन 3 पढ़ा नहीं है
जी।
उसका आखिरी पार्ट पढ़ें।
जी
आप जो रिपोर्ट की बात रीड डाउन करने की कर रहे हैं
जी।
इस सेक्शन का आखिरी पार्ट पढ़ें।
Sir, I'll read the whole. Any matter invoking exercise of original jurisdiction under clause 3 of Article 184 of the Constitution shall be first placed before the committee constituted under Section 2 for examination, and if the committee is of the view that a question of public importance with reference to enforcement of any of the fundamental rights conferred by Chapter 1 or Part 2 of the Constitution involved, it shall constitute a bench comprising not less than 3 judges of the Supreme Court, which shall also include the members of the committee for adjudication of the matter.
आप जो बात कर रहे हैं ना, अगर committee हो तो ये आखिरी words जो हैं they would need to be eliminated.
No,
Obviously,
no.
committee, so the three member committee वो इसको scrutinize करे.
Yes.
Say not maintainable, puts it up before a 5-member judge, of which
No,
those
why
two-
5-member bench? 3-member bench? अभी सिर्फ ये वो केसेस पुट अप करेंगे
से मेंटेनेबल फिर
नहीं। यस, ये तो हर सर चेंबर में अपील जाती है, इनिशियली एक डिसाइड होता है मेंटेनेबिलिटी का इशू, दैट डजंट बार द कोर्ट फ्रॉम डिसाइडिंग द मेंटेनेबिलिटी क्वेश्चन व्हेन इट इज पुट बिफोर अ जुडिशियल
सवाल
बेंच।
जो उन्होंने पूछा वो ये है कि अगर फर्ज करें ये कह दें कि नॉट मेंटेनेबल,
Yes.
then what would be the remedy available to the
No.
aggrieved person?
अगर वो कह देते हैं नॉट मेंटेनेबल, आई वुड से दिस इज व्हाट योर लॉर्डशिप हैज, इसमें सिर्फ ये कहा गया है कि जो मेंटेनेबल होगा वो बेंच के पास
नहीं
जाएगा,
नहीं, अगर फर्ज करें वो नेगेटिव में उसका वो
आप
कर
जो
दें,
read
तो
down-
फिर भी बेंच के ऊपर पास जाएगा सर।
वही judges
नहीं जाएगा, कहाँ लिखा हुआ है?
सर यही तो रीड इन करना है, यही रीड इन करना
बात
है,
सुने, उसमें ये भी लिखा
यही
हुआ है
read in करना है, that is-
which may include members of the committee.
yes
So notionally, it can go before the same judge
yes
again.
yes
And this time you would expect them to hold that it is maintainable.
सर फिर तो रिव्यू जुरिस्डिक्शन भी खत्म कर देनी चाहिए।
दूसरी बात है कि अगर ये
I
कानून
think there's a simple
अगर
solution to this.
देखिए उसको सॉल्यूशंस ढूंढने से पहले जो मौजूदा निज़ाम है इस कानून को एक तरफ रख दीजिए। तो इस मौजूदा निज़ाम में कैसे होता है? देखिए साहब, इधर भी थोड़ी सी
सॉरी
तवज्जो दे दें कभी कभी।
नहीं नहीं सर, आप प्लीज शर्मिंदा पे शर्मिंदा
नहीं तो आप देख कहीं और रहे हैं, तो ज़रा ये देख लीजिए मौजूदा निज़ाम में अगर ये एक्ट तसव्वुर कर लें कि नहीं है बना, अब 184 की आई थिंग, अब तो वो ब्रांच में लिखेगा नॉट मेंटेनेबल, यही लिखेगा ना, या पुटअप कर देगा कोर्ट में या लिख देगा, फिर उसकी करेंगे चेंबर अपील, ठीक है, फिर जज कह देगा दी ऑब्जेक्शंस आर सस्टेन्ड और ओवर रूल्ड। तो ये कहना कि ये जो निज़ाम आया है ये मौजूदा निज़ाम से ख़राब है तो एक अलग बात है।
नहीं नहीं, ये मौजूदा निज़ाम से बहुत बड़ी इम्प्रूवमेंट
अभी तो
है।
वो इख्तियार सारा उसके पास बैठा हुआ है, वो रजिस्ट्रार खुद भी नहीं कर रहा है, वो कोई सब डेलीगेटेड पावर एक्सरसाइज कर रहा है जो पता नहीं जो पिटिशन एंटरटेन कर रहा है, ठीक है। और वो बहुत से लोग शायद अपील भी ना करें, वो भी चेंबर अपील है, वो अगेन वही जज अगर चेंबर अपील में उसने सपोज किया वो कल बेंच में बैठ सकते हैं, क्योंकि वो एक और चीज तरह की नजर से देख रहे हैं, अब बेंच में बैठ के दूसरी नजर से देख रहे हैं।
All cases which go through scrutiny should be put up before a judicial bench.
What is the issue? फैसल साहब ये बताइए, फैसल साहब ये बताइए, क्या जो इसकी डिफिकल्टीज यहाँ पे अभी हाईलाइट हो रही हैं, are we empowered under Article 191 to amend our rules accordingly, remove these difficulties? The power vests in us.
बिल्कुल.
So there, I don't see any
I don't
difficulty
I
or
don't
problem in
see
this.
how this provision is a threat to the independent. If all cases after scrutiny are put before a judicial bench.
Mr. Faisal, यहाँ पे एक चीज और क्लैरिफाई कर दीजिए। 191 के तहत अगर फुल कोर्ट की मीटिंग कॉल करनी है तो किसने कॉल करनी है? Where it is written? Who will call the full court meeting?
So that is to be called by the Chief Justice.
It says the committee now.
Where it is written?
So this is the practice.
Committee will, including meetings and constitution of benches with the committee now.
Sir, वो full court meeting की बात कर रहे हैं, not the constitution of benches.
तो इसका मतलब
Sir, that is a practice. Your lordship is.
नहीं तो practice तो यही है ना कि
want to
that
amend
is
the
to be
rules,
done by
then
the
the other
Chief
judges
Justice.
can call the meeting and amend the rules,
Yes.
and they do it.
Yeah. Sorry?
If the Chief Justice doesn't want to amend the rules, then the other judges can call the meeting and amend the rules.
नहीं उसमें नहीं है।
Sir, these are very difficult questions which I need to really think
आपके
about.
सामने एक सिचुएशन चीफ साहब ने रखी है
जी, बिल्कुल।
कि अगर मैं केस फिक्स नहीं करता तो क्या रेमेडी होगी आपके
सर,
पास?
मुझे इन सवालों
Whether the other judges would be silent spectators?
यही है ना।
Can they call the convene the
ये
meeting?
conflicts है within judges, इनके बारे में
इसका जवाब इसी लेजिस्लेशन में दिया हुआ है। 2 सबसेक्शन 2 पढ़े।
नहीं वो कमेटी की मीटिंग है।
फिर वो कमेटी, वो कॉन्स्टिट्यूशन ऑफ बेंचेस
इससे ऊपर जब शुरू करेंगे तो उसमें कौन सी चीज रह गई है? एवरी कॉज अपील मैटर बिफोर
एडमिनिस्ट्रेटिव साइड पे
ये सब कुछ हो जाएगा।
नहीं सर, ये जुडिशियल कॉन्स्टिट्यूशन ऑफ बेंचेस हैं, उनका सवाल
वो सवाल ये है कि इसमें कौन सी चीज है जो इसमें की गई है।
सर, आई वुडंट लाइक टू रीड मैटर एज इन्वॉल्विंग फुल कोर्ट मीटिंग्स।
ना ये पहली दफा सिचुएशन अराइज हो रही है, जैसे अभी पॉइंट आउट किया गया, तो उसको हम एग्जामिन कर रहे हैं, तो वी नीड योर असिस्टेंस। व्हाट इज योर व्यू पॉइंट?
फुल कोर्ट कॉल करने का तो वैसे भी रूल्स में तो कोई प्रोविजन नहीं है,
कोई प्रोविजन नहीं,
बिल्कुल नहीं।
दिस इज प्रैक्टिस।
देखिए साहब,
जी,
लाइटर नोट, इतने पैसे क्लाइंट ने नहीं दिए।
अब मैं अपने आप को शर्मिंदा नहीं करना चाहता। These are very difficult questions, my lord. I really have to think about that these conflict within judges, how are those to be resolved, whether writs are to be issued, what are the other mechanisms. These have no easy answers. मुझे इस केस के ऊपर सोचते हुए इतने हफ्ते लग गए. I think what your lordships are taking will take me 6 months to really think about.
Mr. Siddiqui, हमने सुना you are a sportsman. कभी कोई टीम ऐसी देखी है जिसके 3 कप्तान और वो जीती हो?
And Mr. Siddiqui, you can ask for the in-camera proceedings.
Sir,
वैसे सिद्दीकी साहब, स्पोर्ट्स से मेरा भी ताल्लुक है, कप्तान और वाइस कप्तान जरूर होते हैं।
सर, सुप्रीम कोर्ट में होपफुली कप्तान भी होना चाहिए, कुलीचियम।
बहुत वक्त ले लिया।
सर, लेट्स मूव ऑन. आई जस्ट रनिंग थ्रू.
सिद्दीकी साहब, कैप्टन एक ही अच्छा लगता है।
सर, Section 4, sir. Section 4 says that whenever an interpretation of constitutional provision is involved, a bench less than not be less than 5. I think,
That is again a dictation.
my lord, I mean, it is.
Shall not be.
Lord, it's.
Why can't the committee say, well, this is an important matter?
But how will that affect? If there is a substantial question of law,
I don't have a question of how will it affect. All along my question is, who is saying it? Who is constitutionally competent to lay down this principle?
If
this rule can be laid down by the court in its rules and
if Parliament has legislative,
in terms of its rule-making powers under 191.
Sir, if Parliament has legislative power, then your lordship has to see whether this rule violates the principle.
That's a big if.
Yes. If Parliament has no legislative power, then this law goes, this provision goes. Otherwise, one looks at this provision.
Mr. Faez, according to you, the Parliament has the
Yes.
legislative. Move on. According to you, Parliament has the power. We will decide whether Parliament has power or not. Now move on.
ये clarity इसमें सिर्फ ये
if the Parliament, if we come to the conclusion that yes, of course, Parliament has the power to make a law, then in law the Parliament may use the word may or may use the word shall.
But even Parliament cannot make a law which will destroy the power of the Supreme Court to make rules and violates the independence of the court.
Okay, so tomorrow the Supreme Court full court says, well, we think 5 judges are not enough, or 5 judges are too much. We want to make it 3. Can they do it?
No. In terms
they
of this, in the presence of this law, they cannot.
Yes.
Yes.
So
And
that means a power of this court has been trumped by legislative instrument.
Sir,
चले आगे बढ़े ना ये आप
the question should be what fundamental rights or independence of the judiciary has been violated. The only thing was that it's a bit badly drafted. The term is actually a substantial question of law involving interpretation. यही term use हुआ है Article 185(2)(f) में.
चलिए देखिए कोई नई बात करें तो फिर दूसरों को सुनने
जी
एक सेकंड, एक आप दिया 3 को रीड डाउन कर दें,
सिर्फ 3 को,
ठीक है. 4 is badly drafted. अभी हम 4 पे आए हैं, अभी आगे 5 से you have an uphill task.
No, but sir, the point is, has ever a law been struck down because of bad drafting?
No.
Or being impractical?
A law can be struck down on various grounds.
Yes.
One of which is, it is vague, it is unclear, it is
not
beyond,
on bad drafting.
It is beyond legislative competence.
But not on bad drafting. अब एक criminal lawyer ने ये law बनाया तो वो constitutional problems तो कुछ होंगी sir. Sir, section 5 sir.
Is that a confession?
You are saying it behind his back.
Sir, मुझे तो यही समझ में आता है.
नहीं ये ना करिए.
Now I come to the main question, which is this problem of a full court and there being no appeal, and the problem that if there are 8 or more, if there are 9 judges, there would be no appeal.
नहीं मगर इससे पहले तो आप ये तो आपने गिवन कर लिया प्रॉब्लम है. देखिए ये ऐसे ना अप्रोच.
नहीं
आप देखिए मौजूदा सूरत हाल में बेहतर थी खराब थी, ये तो कहना ये प्रॉब्लम है कि फुल कोर्ट हो गया तो अपील नहीं है, तो फिर आप इस कानून
मैं इसका जवाब दे रहा हूँ.
नहीं जवाब नहीं होगा, ये क्वेश्चन हो ही नहीं सकता है. मैं बता रहा हूँ क्यों नहीं हो सकता है. सवाल इसलिए नहीं उठेगा.
सवाल तो
नहीं जरा सुन तो लीजिए ना, आप कोशिश कीजिए ना. मौजूदा सिस्टम क्या है, इस कानून को एक तरफ रख दीजिए. आप जरा तवज्जो दीजिए.
जी
मौजूदा सिस्टम ये कि इस कानून को 1 मिनट एक तरफ रख दीजिए. जी अब कौन सी अपील है ही नहीं ना. तो अब आप कह रहे हैं ये कानून जो आया है 99% खामियों और परपोर्टेड खामियों को दूर करने के लिए, वो इस लिहाज से बुरा है क्योंकि वो 1% केसेस जिसमें फुल कोर्ट होगा कोई अपील नहीं है. तो पहले तो फिर अगर आपका ये बात मान ली जाए तो आप फिर तो आप ये कह रहे हैं, आपकी बात में ये इम्प्लाइड है कि ये कानून दुरुस्त है. अब आप 1% के लिए भी अपील प्रोवाइड कर दें तो फिर ये निकलेगा, या तो आप कहेंगे कि जी 99% तो मसला सॉल्व हो गया, 1% कराएंगे.
मैं यही बात कि the mere fact that there isn't an appeal in certain category of cases would not make the law unconstitutional. And I'll tell you why.
They may most certainly be a difference of opinion. One person can think that this is not relevant, but I think that it is very relevant, because when the law gives a right of appeal and the committee has the option of taking that right of appeal away, then it is relevant to the person whose right of appeal has been taken away. If we recognize appeals as being substantive, then that so-called arbitrariness that is being controlled, I don't see how it's being controlled. Because किसी को right मिलेगा, किसी को right नहीं मिलेगा. Again the question will be, ये कैसे decide होगा? Again we'll go looking and hunting for principles, कि कौन सा principle apply करें. So on the face of it, it means that either you can't ever constitute a full bench, you can't constitute a bench which is more than 7 or 8 members, that's it. You're not allowed to do that, because Parliament has said appeal honi chahiye. Aur appeal honi chahiye ka matlab hai that every order of the Supreme Court under 183 has to have a right of appeal. It doesn't mean that I have the option to choose कि अब full court बैठ गया तो सब अब कोई फर्क नहीं पड़ता क्योंकि सब ने केस सुना. Right of appeal is a right of appeal, which we've heard at length yesterday, how we recognize that right of appeal, how Islam recognizes that right of appeal. So यहाँ कैसे हम वो right ले लेंगे वापस and कहेंगे नहीं यहाँ नहीं है क्योंकि हम सब बैठ गए.
Mr. Faisal, if you look at to me it appears to be an intra-court appeal.
Yes.
So at the High Court, if the larger bench is constituted, there's no intra-court appeal.
Sir,
so if there's a larger bench, there's no appeal.
There are 3 restrictions on an appeal from a single judge in an intra-court appeal.
अच्छा ये इसमें एक और बात अगर आप मद्देनजर रखें, हम again realm of conjecture
सिंगल बेंच इस वजह से जब डीबी सुनती है या 3 जज सुनते हैं तो इसलिए उसकी अपील नहीं जाती. लॉ रिफॉर्म itself provides an answer. The appeal provides where a single judge decides the question.
जी मैं
1 मिनट आप सर जी.
देखिए हम कंजेक्चर समाइज पे भी बात कर सकते हैं. अब आप बताइए आखिरी इस फुल कोर्ट से पहले कौन सी फुल कोर्ट थी?
I think 2015 सर.
कितने साल गुजरे?
जी 8 साल हो गए.
तो हम उस केस के लिए सिर्फ फिक्रमंद हैं या हम फ्यूचर के लिए फिक्रमंद हैं? 2 बातें हो सकती है ना. एक तो पिछले के लिए हम फिक्रमंद हैं कि वो केस में वो जो 21वीं अमेंडमेंट टू द कॉन्स्टिट्यूशन है वो एक राइट ऑफ अपील सलब हो गई और वो नहीं हो सकती है. ये एक मफरूजा हो सकता है. ठीक है. दूसरा है कि नहीं हम पिछले के लिए फिक्रमंद हैं तो हम फ्यूचर के लिए फिक्रमंद. फ्यूचर की जब बात आएगी, जब एक्चुअल बात आएगी हमारे सामने, फिर हम अगर आप हमें इतना रिस्पेक्ट देते हैं कि हम आपस में कुछ समझ लेंगे इसको. हमें ये तो नहीं बताना है कि फ्यूचर में क्या होगा. हमारे सामने जो मसला आता है और हमेशा ही कहा गया है उसी मसले को हल करो जो आपके सामने आ जाए. अब क्या मसला होगा आइंदा, हो सकता है कभी फुल कोर्ट हो सकता हो जाए, तो जब वो मसला आएगा फिर आपको सुनेंगे कि फुल कोर्ट बैठना चाहिए, 7 मेंबर बैठना चाहिए, 10 मेंबर बैठना चाहिए, वो सारे बातें इशू खड़े हो जाएंगे. अभी तो फुल कोर्ट एक ही बैठी थी, मुझे जहाँ तक याद है, आपकी बात सही है, 2015 में 21वीं अमेंडमेंट की बात. उसके बाद तो फुल कोर्ट नहीं बैठी, तो ये आई है दूसरी दफा
My answer to the question. This is one way of
When legislation is framed, the legislators are supposed to look at all eventualities and try as far as possible to cater for them. Now, it is so obvious that there is this defect in this law. Was it debated? Was it thought about? Was there a thought process? And thereafter, it was drafted, keeping in mind कि जी full अगर court hearing करेगा तो उसकी नहीं होगी. And if it was thought about it, why was it not mentioned in the
my response would be,
so the obvious conclusion is that there is a flaw, and
there is no flaw.
is so apparent
there is no
that
flaw.
everybody can see it.
No, there is no flaw. It's a self-contradictory question. When you say that there should be an appeal in the full, no legislature in the world can provide an appeal.
Nobody
to
is
the Supreme
saying that there should be an
There
appeal.
can never be an appeal to the Supreme
You
Court.
have actually
There can
misunderstood.
never. It's a
No, Mr. Siddiqui,
self-contradictory
the question is not whether there should be an appeal in the full court. The question is simply that how will this right of appeal be exercised if you cannot constitute a larger bench because you have been stopped from
अभी
doing
हम
so.
full court में
Which
larger bench
means
पे भी-
that when a full court, if the committee decides, whereas in this case, where a full court is sitting, if this law is upheld, that there is no right of appeal. So the question is simply this,
There
that
can never
आपने
be a
खुद
right of appeal.
block कर दिया ना right of appeal. What is the point of giving that
जब
right?
कोई legislature
There is-
दुनिया का अपील दे ही नहीं सकता.
There
आप
is
50 जज हो
another,
जाए.
there is another aspect to it.
But
There
I
is
come to the
another
9
aspect.
judges thing.
You see-
I come to
Actually,
that.
there is no answer to this question.
No,
So
there
we
is-
go around and put a full stop to it. कि जब full court में हम बैठ के, यानी कि हमने जब decide कर लिया full court, तो then there's no right
आप
of
ऐसी
appeal.
चीज की deprivation किस तरह मांग सकती है? तो हो ही नहीं सकती.
You have deprived
लेकिन
someone
दूसरी
something
बात-
that the lawmaker thought was essential.
I think it's
That's
not a,
what you've
it's
done.
not a problem at all. It's not a problem at all.
But मैं कहता हूँ, अच्छा ये 9 member की
साहब ये
Sir,
देखिए एक सेकंड सेक्शन
दूसरी
5
बात
में
ये
लिखा हुआ
है
है
कि
सेक्शन 5 पढ़
ये
लीजिए
जो पावर है
राइट ऑफ अपील का तीन जजेस की कमेटी को दे दिया कि किस में वो राइट ऑफ अपील देंगे और किस में नहीं देंगे.
सर मैं उसका जवाब दे
Is
दूं?
that correct?
Yes, मैं उसका जवाब दे देता हूँ. देखिए, full court I don't think even a right of appeal can be demanded. Now the issue is that in cases.
No, where does the law say that?
Sir, it is an impossibility. You cannot provide. 50 जज भी हो जाए कि आप full court की अपील किस तरह?
Larger bench बन नहीं सकती ना.
देखिए सदीकी साहब
That is
सदीकी साहब
precisely
सुनिए
the point. That it has not even.
सदीकी साहब जरा देखिए इसमें
It has not even been
अपील में ये बताया गया है कि the appeal should be heard by the larger bench. ठीक? लार्जर बेंच के नंबर्स नहीं बताए कि क्या एक जज मजीद बैठ के लार्जर बेंच होगा, 2 जज मजीद उसमें होंगे.
लार्जर बेंच तो हो ही नहीं सकती ना इसके अंदर. जब फुल कोर्ट हो गया तो देयर इज नो लार्जर बेंच फॉर
सॉरी
अपील.
सर सुन ले. लार्जर बेंच की प्रोविजन भी हो सकती है अगर ऐसी सिचुएशन आए.
It's a matter of interpretation by the court and it's sort
ये
of.
हम
Not an issue.
रूल्स में देख सकते हैं. इवन कॉन्स्टिट्यूशन हमें ये इजाजत देता है whenever there is need as per the constitution a judge of any high court can be called for a particular case. तो लार्जर बेंच बनाने की
So इसमें भी हम read in कर
going on too
लेते
much
हैं.
on-
ये इसमें भी हम read in कर लेते हैं कि ऐसे करना है, ऐसे करना.
ये
So आप
read
2
in
provisions हो गए, read in, एक होगी badly draft, ऐसे ही करते हैं.
रूल्स में कर सकते हैं.
Rules cannot read down something which the legislature could never do.
मिस्टर सिद्दीकी, आप रिडंडेंसी तो इस अपील में रिडंडेंसी तो नहीं एट्रीब्यूट कर सकते ना. आपने अपील प्रोवाइड करनी है
नहीं.
एंड इन ऑर्डर टू अवॉइड रिडंडेंसी.
नहीं.
अच्छा
नहीं करनी.
But-
लार्जर बेंच
वो
का
कह रहे हैं,
मतलब ये
नहीं.
फुल कोर्ट के ऊपर अपील नहीं होगी.
आगे बढ़े, आपका हमने मौके पे सुन लिया.
Let me complete. In order to preserve that right, in order to preserve the right of appeal, in essence, you can never constitute a full court.
Sir, because full court पे अपील हो ही नहीं सकती, तो you can always constitute.
तो आप उसको
In that case, there'll be no appeal.
flipping the argument.
चलिए आगे बढ़े ना
आगे
फिर.
चलिए.
Sir,
आपका मौके सुन लिया, हमने कहा नहीं हो सकती. चलिए
सेक्शन 2 रेट्रोस्पेक्टिविटी का इशू था. ये अपील दे दी गई है रेट्रोस्पेक्टिवली. सर, there are two principles which will radically reduce the right which have been given. The first was pointed out by Justice Athar. This is an appeal against orders passed under Article 184(3). If an order has been passed after that under review jurisdiction, the appeal will not lie. These are orders which, that's the first thing.
नहीं
All
नहीं, एक
review-
सेकंड. Does the law say this or this is your interpretation of the law?
सर 184(3) के ऑर्डर्स है ना. अगर आपने रिव्यू फाइल कर दिया, उस पे रिव्यू का ऑर्डर आ गया.
188
अगर किसी को अभी किसी का रिव्यू पेंडिंग है एंड ही वांट्स टू रियली हैव द राइट ऑफ अपील, ही हैज टू विथड्रॉ हिज रिव्यू.
I mean, you see, there is no cut-off date of filing appeal. There is open-ended.
There is a
From
cut-off
where it
date for
will start.
filing appeal.
Mr. Siddiqui,
जो
वो सिचुएशन देख लेंगे ना.
सर सेकंड प्रिंसिपल मैं बता दूं. सेकंड प्रिंसिपल
अरे आप मफरूजों पे जा रहे हैं. वो what may or may not happen, but just tell us. देखिए, surely it boils down to one thing. Some of us think the law should be struck down because the right of appeal is not being extended to what will happen to the scenario when there's a full court. ठीक है. Others think it doesn't matter. Fine. I'm just saying, can you strike down a law creates a right of appeal, but it is to be struck down only because in one given scenario there is no right of appeal?
And sir, no law can be struck down on the argument of floodgates. No law
चलिए
can
अब
be
आगे बढ़े ना, आगे
आगे
बढ़े.
The second restriction is that in every retrospective law, your lordships have said that this retrospectivity will never apply to closed and past transactions और वो vested rights have accrued. Sir, 1/3 के 1% से कम cases होते हैं.
आप बात सुने.
आपने review निकाल दिया, आपने
ये
vested right
argument
निकाल दी, closed and past
कल ये
transactions
argument
कितने
हुआ,
केस बच गए?
कल ये argument हुआ कि इसको आप read down कर लें, read down कर लें, and it actually means 30 days. Within 30 days of filing of the promulgation of this act, जो decisions आए हैं या before उसके आए हैं within 30 days, तब से वो limitation start होगी. लेकिन 1973 से या 1974 से नहीं होगी. ये भी argument आया और हमने note किया.
Sir, I'm not arguing. There is nothing wrong with this provision if these two principles are.
All right.
I'll move on.
Mr. Siddiqui, 184(3) is a constitutional provision.
जी.
It is original jurisdiction.
जी sir.
Appeal is continuation of the same.
जी.
How a law which is legislative incompetence because of not being a constitutional provision that can be provided by a simple lawmaking power of the legislator.
I have extensively dealt. अगर आप note देख लीजिएगा उसमें.
See your jerky motions
I just
that
want to क्योंकि बहुत वक्त हो गया है. अगर आप allow करें मैं जरा
Simple बता दें आप.
It's your jerky motions that distracts judges. They don't get to concentrate on your arguments.
Sir, there is no bar under Article 184(3) that it bars that you can't create an inter-court appeal, and that has been done in other laws also. I mentioned two laws: the Law Reforms Ordinance, Constitutional Forum, appeal is provided.
It is in entirely different premises.
No, my lord, I think it is clearly, and that is what when I had read the judgment.
It has been explained by Mr. Ijazul Hasan and very thoroughly that has been explained.
My lord, I would beg to disagree. And then, of course, there is the appeal in the contempt of court orders. But now I'll come to the most difficult part, and with the utmost respect to the benches, which is
incidentally for the third time you have said, I now come to the most difficult part. So,
you're moving stepwise.
Every section of this law is so convoluted and difficult that
I have stated the reason why the law is so difficult.
Every section is the most difficult part of your argument.
The most difficult part is that one never wants to say that, your lordship, there is a judgment which should be revisited. There are two judgments, and they have been rightly cited by the petitioner's counsel, my lord. One is the Bas Kakar case, where they have relied on certain principles of law and constitutional principles on the basis of which they seek the striking down of law. I will not go into the detail of this, my lord. I'll just point out the pages. Page 1993 to 1995 deals with section 8 of the Contempt of Court Act 2012.
ये कौन सा पास मोहम्मद वाला है?
जी, PLD 2012 Supreme Court 923.
923.
Now, my lord,
इसमें
sir, 993 to 995.
995 इसमें क्या खराबी है?
Sir, section 8 in the Contempt of Court Act.
ये कितने जजेस का?
Sir, मेरे ख्याल में 5 दिखाओ बेटा, 5 member. 1, 2, 3, 4, 5 थे सर.
अच्छा, इसमें ये पेजेस गलत हैं, क्यों?
नहीं, ये पेजेस गलत नहीं है, distinguishable है. The reason is that if your lordships looked at section 8, which was struck down, of the Contempt of Court Act 2012, which I have attached in my notebook, वो ये करता था कि एक जज ने कॉग्निसेंस ले लिया है एक कंटेम्प्ट का, और वो ये कहता था कि ये ट्रांसफर कर दें. चीफ जस्टिस ने कॉग्निसेंस ले लिया और कहता था ट्रांसफर कर दें. So it was really interfering in judicial orders. Now, when it came to the appeal, what the Supreme Court has done is that it has said that section 19 में जो appeal है वो ठीक है. Those are pages 1000. Those are pages. वो दिखाना मुझे जजमेंट दिखाना. It's para 82.
पैरा 82 ठीक है, पैरा 82 ठीक है, कोई फर्क नहीं पड़ता है।
एक मिनट,
पेज बता रहे, पेज नाम बताइए, 82 से
1004
ठीक है, पैरा 82 हो गया, हम ढूंढ लेंगे।
para 82, and after striking down the 2012 Act, that law is revived. Now, the problem with the appellate appeals provision in the 2012 law was कि सर उसमें लिखा हुआ था एक अपील फाइल होगी, वो किसी शो कॉज के खिलाफ, हर किसी के खिलाफ, और फिर फुल कोर्ट बैठे सारे जज बैठेंगे। मतलब सारा पावर ऑफ कॉन्स्टिट्यूशन और बेंचेस ले लिया गया था, और उसमें लिखा था फौरन सस्पेंड हो जाएगी। So that was such an interference that though whatever has been said,
No, but can't you reconcile it by simply saying that in that case the parliament did something so extreme to protect people of a particular who have been may have committed contempt, therefore the court found necessary to intervene. Here maybe they have not done something so extreme.
And the law was, I think, unconstitutional. So वो distinguishable है, provisions देख लीजिएगा. Now I come to the judgment which, with due respect, I think if the law is to be upheld, this law has to be revisited to a certain extent. If your lordship may kindly see, sir, this is called the Ghulam Mohyuddin case.
Citation देते हैं.
Sir, ये unreported है. It is 11th August 2023.
11th August, ये कितने member bench है?
SMC के क्या?
Three member bench. नहीं, this is constitutional petition number 21, 22, 23 of 20. मैंने लगाया है वह सर अपनी पेपर बुक.
ये कहीं रिव्यू वगैरह में तो नहीं पड़ा हुआ है?
Sir, this is in review also.
रिव्यू में फैसला हुआ है?
नहीं.
तो फिर इसको पता नहीं मुनासिब है या नहीं इसके मुताबिक।
Sir, there are passages in this
तो
judgment.
अगर इसमें देखिए, अगर हम फिर उसको रिव्यू को फिर रिडंडेंट बना देंगे।
Sir, वो बात, I think even if those passages are revisited, the judgment on its own would stand.
नहीं देखिए,
But there are passages.
नहीं फैसल सिद्दीकी साहब, दो बातें हैं। पहली बुनियादी बात है, अगर एक वो रेगुलर उसमें आया है हमारे पास रिव्यू में, जो राइट एक्सरसाइज है, उसको हमें बात नहीं करना चाहिए। अब जहाँ तक असूल की बात है, अगर इस केस में जिस तरीके से भी फैसला किया, असूली फैसला किया, अब उसका शायद असर उस पर पड़े या ना पड़े वो तो एक अलग बात है, क्योंकि लार्जर नहीं वो हम देखें उधर जाने नहीं चाहते हैं, तो इस केस का जिक्र ही ना करें बेहतर।
My last point and then I will conclude, sir. Page 8.
One thing I need to add. This law, which is under challenge now, was promulgated on the 21st of April 2023. Or review of judgments law immediately after that, which is 26th of May 2023. And if you go through, compare both laws, they are a repeat of each other almost, except that in review they said कि जी review में वही grounds होंगी जो appeal में हो. And it was pointed out to
Sir, वो poem थी ना, try again वो.
उसका क्या बना?
Okay, you answered that.
उसका केस
You answered my question. Try again. There was so much desperation.
नहीं, वो सेटिस्फाइड हो गया
जी।
उसमें भी रिव्यू है या नहीं है?
नहीं, ये वाला रिव्यू वाला तो
नहीं, ये जो दूसरा
नहीं, ये उसी की बात कर,
उसमें भी रिव्यू हुआ है या नहीं?
जी, नहीं सर, उसी की बात कर रहे हैं, उसी की बात की।
अच्छा, इसी में?
जी।
अच्छा, ओके।
इसमें जो
एक और केस
हुआ, ये subsequently आया।
Sir, last point, which is page 8 of my note.
Whether last point is difficult or easy?
नहीं सर, ये सबसे आसान है. This might actually unite the court. Sir, if your lordship comes to the conclusion that any part of this law, let's say section,
don't throw the baby out with the bath water.
Sir, ये सारी जो provisions है अगर आप देखेंगे तो independent है, सिर्फ 3 और 4 का ताल्लुक है 2 से, और किसी का ताल्लुक नहीं है. 3 or 4 refers to the committee in section 2. Even section 2, if it's upheld, and section 3 and 4 are not upheld, it will not make a matter. So if your lordship comes to the conclusion, I hope your lordships and ladyships, but then the doctrine of severability can be applied in this case. It couldn't have been applied in the 2012 case. I'm very grateful to your lordship for a very patient hearing, to all your lordships and to your
Well,
ladyships.
thank you.
Ji.
At least speaking for myself, I compliment you for
Thank you, sir.
answering or trying to answer all the questions to the best of your ability.
Thank
and
you,
you were
sir.
well prepared.
Thank you, sir.
I'll
Professor,
add my voice to that.
You must thank us also, we made you exercise, lose calories.
Thank you, sir. Thank you. Very kind, sir.
अब कितने लोग रह गए बता दें कौन कौन से हैं कोई जो मुख्तसर वाले हैं किसी ने आप कोई नई बात क्योंकि काफ़ी तफसीली आपको फ़ायदा मिल गया जाहिद इब्राहिम साहब और कौन थे फैसल सिद्दीकी साहब का
नोट इसमें सबमिशन यही थी कि हमने प्रेस रिलीजेस भी इशू किए हुए थे रेजोल्यूशंस भी थी कि फुल कोर्ट की कॉन्स्टिट्यूशन हो
वो तो हो गया
माय लॉर्ड
बगैर आपकी प्रेस रिलीज पढ़े हुए
माय लॉर्ड
अच्छा
वो हमने सीएम लगाई हुई
नहीं तो आपने जो बातें अगर लिख दी हैं तहरीरी तौर पे तो वो हम पढ़ लेंगे अगर आपको कुछ मजीद कोई खास पॉइंट रह गया है जो इनसे छूट गया है तो बता दीजिए नहीं तो काफ़ी अटॉर्नी जनरल मेरे ख्याल में मेन आदमी शख्स होंगे
इसमें सबमिशन यही है कि जो एक्ट पास
नहीं आप इसको सपोर्ट कर रहे हैं
मस्त
अच्छा
तो एक्ट पास
तो ये बताइए ये क्यों डिवीजन क्यों आया है वकीलों में पाकिस्तान बार काउंसिल एक मौक़िफ़ ले रहा है सुप्रीम कोर्ट बार एसोसिएशन दूसरा मौक़िफ़ ले रहा है ये काफ़ी भाई कानूनी बहस है
लेकिन इससे पहले सुप्रीम कोर्ट बार ने जो रेजोल्यूशन और अपनी प्रेस रिलीजेस दी हुई हैं वो इसी पर्पस के लिए दी हुई हैं वो अगर इजाज़त हो तो मैं पढ़ लूँ मैं लॉर्ड
आपने फाइल की हुई है नहीं हम देख लेंगे अगर फाइल है तो ठीक है
अब ये
आपका सीएमए नंबर से बता दें
इसका आसान जवाब ये है रीजनेबल माइंड्स कैन डिफर
यस मतलब और इसमें सबमिशन यही है
अच्छा रीजनेबल माइंड्स वो आप अपना सीएमए तो बताइए नंबर पाकिस्तान बार काउंसिल ने क्या फाइल
किया माय लॉर्ड 4207
8087
एक सीएमए नंबर
और 8087
सॉरी दोबारा आहिस्ता आहिस्ता कहिए एक शख्स बोले
जी मैम 420 पहले ये अलाउ हुई है और 8087
ये तो हो गई फुल कोर्ट हाँ अच्छा ओके
8087
दूसरी कौन सी है
8087
हम आपको कब ख़त्म नहीं करना चाहते मगर अगर वो बातें हो चुकी हैं वो दोहराने वाली बात नहीं है तो फिर रहने दें
मतलब इसमें सबमिशन सिर्फ इतनी थी कि जो एक्ट पास हुआ है उसमें सुप्रीम कोर्ट की पावर्स को इनलार्ज किया गया है उसमें कर्टेल नहीं किया गया और उसमें अगर एक जज के पास ये इख्तियार था तो वो अब 3 जजेस साहबान के पास इख्तियार आ गया है और अगर वो विद द कॉन्सेप्ट जिस तरह कुरान में भी है कि मशवरे के साथ अगर किया जाए इसलिए कि पहले मशवरे नहीं होते थे तो जिस वजह से हमने और सुप्रीम कोर्ट के फैसलों में हमने सफ़र किया है और ऐसे ऐसे फैसले भी हुए हैं जो कि सुप्रीम कोर्ट के जजेस साहबान ने जिस तरह जुल्फ़िकार भुट्टो केस है उसमें नसीम हसन शाह खुद एडमिट किया था कि जो ऑर्डर हमने किया था वो हमारी गलती थी और कोई प्रेशर था तो इसलिए मेरी सबमिशन ये है कि ऐसे ऑर्डर किए जाएं कि जिस तरह आर्मी चीफ को ये भी इख्तियार दिया जाता है कि वो प्रेसिडेंट भी बने और आर्मी चीफ भी रहे और 4 आर्मी चीफ जो हैं वो हमारे प्रेसिडेंट भी रहे इन यूनिफॉर्म और इस बात का तल्लुक कोई किसी कॉन्स्टिट्यूशन से नहीं है किसी कॉन्स्टिट्यूशन में ये मेंशन नहीं है कि एक आर्मी चीफ होगा और वो सेट होगा और वो इलेक्शन लड़ेगा और प्रेसिडेंट ऑफ पाकिस्तान बने इसलिए ये हमारी खुशकिस्मती है
कहना ये कि इंडिपेंडेंस ऑफ जुडिशरी पे इसका कोई असर नहीं बल्कि
मतलब डेफिनेटली इसलिए कि प्रीवियसली जुडिशरी ने इंडिपेंडेंस व्यू नहीं दिया इसलिए कि कॉन्स्टिट्यूशन में एक इख्तियार है ही नहीं है तो वो भी दिया गया और उन्होंने 11
आप क्या कह रहे हैं कि अपील का हक देकर के इंडिपेंडेंस ऑफ जुडिशरी बढ़ती है कम नहीं होती है ये
बढ़ती है माय लॉर्ड
अच्छा
इसलिए कि अगर वो राइट दिया गया है अगर एक जज साहब के फैसले से कोई सफर करता है तो वो 3, 5 और 9 और इस तरह सुने
आज़ाद अदलिया
तो इसलिए मेरी सबमिशन ये है कि जिस तरह प्रीवियसली हो गया है कि जफर अली शाह केस है उसमें फुल बेंच ने ये ऑर्डर फरमाया हुआ है कि आप चीफ एग्जीक्यूटिव ऑफ द कंट्री भी हो गए आप कॉन्स्टिट्यूशन भी अमेंड कर सकते हो और आपने राइटली एक पॉलिटिकल और डेमोक्रेटिक गवर्नमेंट को डिसॉल्व किया तो इस तरह के अगर होंगे तो हम आगे फ्यूचर में नहीं चल सकेंगे मेरी सबमिशन सिर्फ इतनी है कि फैसले ऐसे किए जाएं वो जो कौम को और दुनिया को नजर आए कि वो जुडिशरी ने फैसले
तो आप समझते हैं कि इस तरह हो कि आज़ाद अदलियत तो हो लेकिन कानून और आइन के पाबंद
आइन की पाबंद ठीक है
थैंक
यही मेरी सबमिशन है
ठीक शुक्रिया आपको कितने लोग रह गए
Arguments हो तो ऐसी
Is it short or is it long?
I'll try to be short already had audience on the first hearing. I have filed written submissions and additional submissions, but I'll try to conclude my submissions in 1 hour, not more.
Who would leave you to conclude your arguments in 1 hour?
Not so.
You will
I
be
said I
bombarded
will
with questions
You
now.
can't get away that easy. No, no.
I said 1 hour for me.
कल आप हैं इधर?
I am.
कल कोई मेरा केस तो नहीं है कोई बड़े वाले कोई बंचेस एक रखा था ना बहुत बड़ा हाँ हाँ तो कल फिर खैर में आप भी जरा फ्रेश हो जाएं हम लोग भी जरा फ्रेश माइंड्स के साथ बैठेंगे अगर आपको अगर यू आर हियर यू नॉट
I've noticed that in the first half an hour one can get away with questions and make substantial progress.
You're going to regulate us.
Today I noticed that.
Are you going to regulate us? Are you going to tell us we are going to conduct ourselves?
I'm just hoping this is an expectation.
It's a hope against hope. It's not going to happen.
Regulating the Supreme Court appears to be the one thing these days.
Not
Flavor of the day.
ओके अच्छा आ गए सर रिश्ते आ गए कहती ना रिश्ते आ गए जी हाँ सॉरी ऑर्डर भी डिक्टेट ही कर दें आपके सामने थैंक यू फॉर रिमाइंडिंग 2 मिनट ठहरिए क्योंकि गलती वगैरह हो फिर आप हमें करेक्ट कर देते हैं इसमें लिखिए इन सपोर्ट ऑफ द एक्ट मिस्टर फैसल सिद्दीकी नहीं एम क्या असली नाम क्या है आपकी पार्टी का किधर गए वो
I think it's MQM.
He's gone?
Muttahida Qawmi Movement.
अच्छा
Muttahida Qawmi Movement.
मुत्तहिदा कौमी मूवमेंट पाकिस्तान या कुछ तो नहीं लिखते हैं ब्रैकेट में कर दें MQM is represented by learned Mr. Faisal Siddiqui, who during the course of arguments submitted a booklet and said he had not filed anything else. Full stop. He semicolon. He concluded his submissions. Whereafter, आप उनके नाम लिख दें पाकिस्तान बार काउंसिल के वाइस चेयरमैन एंड
Vice Chairman Executive Committee.
और आप अच्छा ठीक है stated that they stated that they filed 2 applications. The first CMA number 4207/2023, which sought the constitution of the full court as fructuous in the full court is hearing this case, and their contentions are contained in the other CMA 8087. Full stop. आप इनके submissions adopt करते हैं या नहीं? They further state that the submissions made in support of the act they adopt and don't want to repeat for the sake of क्या होता है? To avoid repetition. ठीक है. Learned Attorney General, it is now almost 4 p.m. Learned Attorney General states that he will take about an hour to conclude his submissions. Adjourn to कल तारीख Tuesday, Wednesday, 11th October 2023 at 11:30 p.m.
AM.
Yes. I'm tired.
Why not
Just
today?
as well. Uzair Saab ji.
Sir,
By the way, it's been a pleasure to hear you also.
My lord, I am so grateful, ji. I am so grateful. My lord, sir, a request thi ji, and I hope all council will join me in that request. Each one of us has been assisted by our colleagues and associates. If their attendance could also be marked in
On
their
one
names.
condition, you all of you give affidavits that you have properly remunerated them also
My
for
lord,
the.
certainly, my firm has. My firm has.
I'm more interested in safeguarding the interest of the youngsters.
My lord, I am more interested in it than your lordship, and I can assure you of that.
चलो ये अच्छी बात
We
है।
take good care of us. So ये मेरी एक request थी जी। अगर-
वो आखिर में लिखें या अभी लिखें?
जब main judgment में जब
Main judgment.
judgment में जब
Tomorrow's order.
लिख के नाम देना सारा।
अब ऐसा करें कि अगर वो हम अभी तो ये छोटे छोटे ऑर्डर्स हैं ना इनको पता नहीं पूरा दिन लग जाएगा उनको नाम लिखने में
आपके स्टाफ को मैं नाम दे के
नाम सारे दे दें।
नाम दे दें।
वो जब
मतलब आपको एक नाम देंगे ना हर आदमी नहीं कि 50 लोगों के नाम पूरी फर्म के लिख दें
सर मेरे जी दो
आप देख लें, फिर हम देखते हैं कैसे होता है, कितने
मैं
नाम
नाम
आते हैं,
दे
ठीक
ठीक
है?
है
आप लोग सब दे दीजिएगा।
ठीक है
That we may or may not depend on all of us, incorporate them in the
ठीक है सर, मेरी
judgments.
रिक्वेस्ट थी, बाकी आप देख लें।
ठीक।
Let committee.
No, let the master of the rolls. Thank you, everyone.
Grateful, sir.
Constitution, they revert the position back to Government of India Act 1935 in terms of the legislative competences, because I'm now focusing on your entry 58 argument. Now, if that argument is correct, it seems to me that that indirectly resurrects a legislative entry with regard to the, specifically with regard to the Supreme Court, which has been removed from the legislative lists, and it recreates indirectly something which the interim constitution and the 1973 constitution very firmly say, as I understand it, modeling themselves on, in this regard, on the 1935 Government of India Act, that indirectly brings in, resurrects the legislative entries that were there in 56, which to me creates this problem. Firstly, as my learned colleague some while ago said in a different context, but this is indirectly amending the constitution. Secondly, it seems to me the very broad manner that you are talking about with relation to 58, I think that puts in doubt whether law as used in 191 is supposed to be an enabling power at all, because you are now creating a legislative competence, as you say, in the widest, broadest possible terms, which does not exist in the Constitution. What would you say to that?
My humble submission is that, and reading of Article 191 is that when it says that Supreme Court may and they shall be subject to the Constitution and law, I read it that on that issue, on that subject, there is a law or can be a
मैं आपकी जो है ना, I'm sorry to interrupt you, but I'm trying to understand जिस तरह आप इसको 58 से लिंक कर रहे हैं ना, the practice and procedure parts of this act, आप जिस तरह इससे लिंक कर रहे हैं, तो then necessarily the subject, the legislative power or competence of law in 191 has to be in the broadest possible terms. But that is only possible, it seems to me, if the 73 constitution had retained what was to be found in 56 and 62, namely specific, आप जरा पढ़ें तो सही, दीजिए साहब को 56 constitution दें साहब को और 62 constitution दें, उसमें वो legislative entries जो सुप्रीम कोर्ट की हैं वो पढ़ें तो सही ना, आप तो उस चीज को रिक्रिएट कर रहे हैं इनडायरेक्टली. आप काइंडली रीड दोस लेजिस्लेटिव एंट्रीज. आप पढ़िए वकील साहब, पहले पढ़िए तो सही ना. 56 का है 5th शेड्यूल.
Is this your argument, Mr. Zaid Ibrahim?
No. I'm trying to, I'll read 56 Constitution.
5th schedule.
I think it's entry number 16.
Fifth, yes. Entry number?
I think maybe 16.
16.
It's on the Federal Legislative List, 5th schedule. Entry मुझे याद 16 बोल रहे हैं 16.
16.
हाँ 16 है ना, entry 16 देखिए, Federal List entry 16.
The Constitution, organization, jurisdiction and powers of the Supreme Court, including contempt of such court and the fee taken therein, persons entitled to practice before the Supreme Court.
और अब आप इसकी देखिए 62 Constitution की, वो भी चले ना रहने